My name is Muhammad Asad Yunus and my student ID is 210300653 and this is my student code. I am here to represent the Ethicorp Albanian-based company in the proceedings of arbitration against the Kingdom of Spain. First of all, I would like to explain the bilateral investment treaty. Basically, the bilateral investment treaty is the treaty between two states who settle the principles and rules for their individuals and for their companies to invest in the one and other states. This is the reciprocal thing. The both rules and the treaties, the rules and regulations apply on the both states in here. The bilateral treaty between the Spain and Albanian government signed in 2003, and this bilateral treaty consists on 13 articles. Ethicorp specialize in electrical communication in end of 2019, and after then the Spanish government appointed them to enhance their existing the prevailing telecommunication system, and they take over the telecommunication system in end of 2019, and the Albanian and Spanish governments, the relation between both states prevailing from many decades. They signed to many bilateral treaties between them, and both countries are the members of the NATO, and both countries are sharing their territorial defense system, and they are sharing their national languages in both states' educational institutions, and they exchange their norms and customs in terms of harmony in culture. And the issue arose when the Albanian company Ethicorp terminated by the Spanish government in the mid of 2021, and then when they invested their huge capital in Spain, and the Spanish government terminated without negotiation and without following the terms and condition which was settled in the BIT in 2003. And now I would like to assist the court in the matter of jurisdiction. This court, this arbitral tribunal has the jurisdiction to entertain this arbitral proceedings, and according to that Article 25 of the ICID Convention, the arbitral tribunal consists on 3 members. The first 2 members elected by the 2 parties of the arbitration proceedings, and the other one is elected by those 2 elected members of arbitral tribunals after the 5-month when they were appointed, date commenced when they were appointed, and if no either party elect their member of arbitral tribunal, so then the case shall be sent to the International Court of Arbitration, and they appoint the members of the chairman of the International Court of Arbitration appoint the member of the arbitration tribunal. If the chairman hail from or belongs to any either state. So the vice chairman of the International Court of Arbitration appoint the members, and if either he belongs to either state as well, then the other member of International Court of Arbitration, his most senior, shall appoint the member of the arbitral tribunal. So the foreign investment refers to the investment when a domestic country invests their capital, or any company of any other state invests their capital amount to any other country to purchase the assets of the other country. So the investment is of two kinds. The first is direct investment, in which people, in which the companies or individuals buy the machines and properties and other things like that. And the indirect investment, the companies and the individuals buy purchase the shares of companies in stocks and exchange, and the uh, and bonds as well. And according to the Article 1 of the VAT, between the Albania and the Spain, the investor is the person who invests the capital in any other states, and the national means any person of the state by law registered in any state where they belongs to. And the company or the organization means any legal entity which formed in to follow the due process of law of that state is refer the company. So now I would like to throw the light on the legal breaches of this agreement in part of Spanish government. The first and foremost, the Article 2 breached by the Spanish government. They refused to give the license to after investment of the capital, huge capital by the Albanian Ethicorp company. So this the fair and this is the breach of a fair and equitable treatment. They discriminate the Ethicorp with malicious intentions, which has basically the FET, fair and equitable treatment, is the safeguard which provided to the foreign investors to protect from any discrimination in the state, and to effect any other any customs for this country. These safeguards are basically protect them from any sort of discrimination in the host state, basically. So now I would like to uh, talk about the other breach of Article 3. So the Article 2 and 3 contain the fair and equitable treatment and the full protection security. The either host state is liability of the state to provide the security in any adverse circumstances. They should direct to their security agencies to protect the foreigners, companies and workers and the assets of company as well. And the protection is two kinds. First is the physical protection, the other is the protection of the assets, properties. And the other thing is I would like to discuss the most favored nation treatment. The most favored nation treatment clause linked with the investment agreements. They to ensure the parties which are entered in agreement, they settle uh, the standard of the treatment that should not be less than the favorable than the treatment they provide under treaties in area covered by the clause. So, according to the definition of most favored clause, and the Spanish government breached the Article 5 of Article 4 of the BAT, and Article 5 is contained the procedure for expropriation for both countries. Uh, the procedure provided in this article is that no any country terminate any agreement without any lawful justifications, and no country terminate directly to any company of the either state. Basically, expropriation is the procedure in which any state overtake the company and seize the asset of the company. But expropriation is of two kinds: the direct expropriation and the indirect expropriation. The direct expropriation is the direct way when any state sees the assets of the company and overtake it and eject the any responsible authorities of the company from the state. But the indirect expropriation is the way which is after termination of agreement, they send the different notice to the company, and they ask different reply from different subject matters. But the whole expropriation in this Article 5 of the BAT between Albanian and Spanish government, this is settled that no country shall be expropriate any country without follow the due process of law, and after and the when any country expropriate any foreign company of the other state, they must be give some compensation in form of the fiscal rate existing in the current time, and there are different terms and conditions settled in to compensate the company in case of expropriation. So there are different cases, and I want to give the reference of Pakistan and Australia VAT, which are also terminated according without following the procedures mentioned in VATs and others. So I just want to conclude and add some circumstantial effects in this case. So the agreement done in the end of 2019 between the Spanish and Albanian Ethicorp company, then the company appointed for establish the electrical telecommunication uh, roadmap. Then then the outbreak of COVID, the whole world is stock out, and there are a lot too much complications and difficulties to carry on the work on working place. There's the a shortage of labor, there's a shortage of stock in markets, there's a lot of other traveling and carriage problems are prevailing in that time. So the Albanian, despite of this, Albanian company Ethicorp performed very well, and they are try to achieve the um, achieve the good results, but due to these global issues, uh, they have some problem. But Spanish government did not provide them the fair and equitable treatment and full protection, security, and the way of expropriation um, uh, is against the rules settled in the BAT. So it's in conclusion, we can say that the whole burden is on the side of Spanish government. Spanish government breached the Article 2, 3, and 4, and 5 as well, and no give the chance to renegotiate the agreement. And in prayer clause, I would it's my humble submission to the arbitral tribunal that they after hearing this case, they provide us the remedy, and they provide us remedy and do justice according to the prevailing law, and after reviewing the all facts and figures of this case. Thank you.